Hello everybody, Brian Keen from How to Franchise Simply here with one of my regular teleconferences. I'm really thrilled today to be able to interview Christopher Whitelaw. Chris is a barrister of some note and an interesting man with a fascinating background and some tremendous knowledge to share. Essentially, one of the reasons that I spoke to Chris, approached him about being available for this interview, which I'm privileged to be able to have offer to you, is that he specialises in really working with people, with clients, particularly in the commercial area, who have a dispute and finding ways to resolve it quickly at little cost and without hurting important commercial relationships so that you can get on with business. So he's written a fascinating ebook, which I'd certainly recommend to all of you today, called The 7 Steps Guide for Small Business to Give Commercial Disputes the Slip, or How to Stay Out of Court and Stay in Business. I love that because that's what it's all about. Anyone in business, especially, I suppose, franchising is a sector that's seen as having a little bit more friction than others, although I don't know if that's necessarily valid, but nevertheless, whether you're a franchisee or a franchisor, you need to be familiar with this process because in life, it's going to be of value to you at some stage, I almost guarantee. The truth is that going down the litigious route has the potential to destroy our businesses. I know I certainly lost one business through a legal dispute that there was no making of mine, and I resented forever the fact that I didn't manage to get it mediated beforehand, because they could have saved a lot of money, a lot of time, and a lot of stress, and probably given me less grey hair. So I think you need to take every step you can to avoid that. So as the doctor would tell you, prevention is better than cure, and these 7 steps have been written by Chris to help you bulletproof your business so that, you know, the threat of litigation, which is always hanging from one direction or another, it can be created quite easily, so that you've got really, I suppose, a card to play against it. Chris is very well qualified in this area. He's got over 30 years of experience accumulated dealing with commercial disputes, and he still smiles and laughs, so you've got to say. His first 20 years was as a commercial lawyer and then as a barrister, a career I've always sort of envied, actually, always fancied that, but I don't think I'll make it now. And so he spent time preparing, you know, cases for court and arguing cases for clients. And goodness me, must see an extraordinary potpourri of people and circumstances. Appeared on many panels as a commercial arbitrator. From, let's see, year 2000, he obtained his master's degree in law and specialised in what's become known as an area as alternative dispute resolution, ADR. And it's something that you should be yourselves familiar with, and that's what we're going to learn a bit more about today. It's really focusing on how to manage disputes, get them resolved without going to litigation. Now, over the last 5 years particularly, Chris has specialised in commercial disputes, including those in franchising, and his track record is formidable. He's actually shown hundreds of businesses how to set up their risk management sort of programs, bulletproof themselves so that they can avoid litigation, and if there are disputes, get them resolved quickly and effectively so they don't get caught up. So let's get the ball rolling. Chris, good afternoon to you. Thanks for making yourself available.
Good afternoon, Brian.
I suppose we'll run into the intro here because effectively the heading here, which you may be listening to in audio or you may be watching, according to your media using, how to resolve disputes without litigation, without damaging important relationships. So in looking at that, I suppose what I've encompassed there, the first question I've got for you, Chris, is really, why should franchise business owners in particular take this seriously, this risk of litigation?
Yeah, thanks, Brian. In fact, I guess in putting that in a little bit wider ambit, and as you indicated early on, the relevance of what I'm speaking about here and what's in the guidebook is there both for franchisors and franchisees. Many franchises, I guess, would fall into the category of being called an SME, a small to medium-sized enterprise, and that's my particular focus, and it's the particular focus of the Commercial Disputes Management Center, because bigger corporations have an alliance, if you like, with the top tier law firms, and they're pretty well taken care of, and they have plenty of money to throw around, which SMEs don't. So a big corporation can take on excuse me, a hefty bit of litigation, and they may have a particular agenda for it, and they may be willing to spend a great sum of money for it because they take the view commercially, if they win that litigation, that gives them the upper hand in a particular niche that they're operating in, or a particular business advantage over competitors. But this is not really the sort of playground for SMEs. And as far as I know, most SMEs have to keep a careful eye on their cash flow, and being suddenly drawn into litigation can consume a lot of your cash flow, and possibly fatally so that you can't properly carry on business. So it is a very significant threat. I call it litigation hijack, and as you said, it's ever present. And the litigation hijack, really, it comes around like this. If you don't set up your business in a way that I'm going to explain in this interview, and it's explained in the guidebook, with the risk management written into it, and you don't bulletproof your business, then if a dispute emerges, it leaves it wide open to your opponent, if they want to use whatever leverage they can get, and if they happen to be in a position where they can choose to use litigation rather than some alternative method, simply to pressure you, simply to get the upper hand, and they may, and some will, most definitely. So that's what I call litigation hijack, and that's what anyone in business is exposed to if they don't follow these 7 steps and bulletproof their business. They are, as I term it, an accident waiting to happen. So there's 2 million SMEs out there, I'm told. Yeah. Franchises are amongst them, and it's just no point going into and paying money to go into a new business and putting all the effort and creativity and whatever else into it, and then being an ostrich and sticking your head in the sand concerning litigation, or the threat of litigation, saying this will never happen to me. That's a fool's game, and I don't recommend it. So this guidebook is written for the SMEs, and if that's you, then I hope what I'm about to say here will be helpful to you.
No, that's a great illustration, and certainly I know from my experience that one ends up in these unfortunate situations when you end up with a dispute with someone where they draw a line and they're fighting on principle as opposed to having any practical reason for what they're doing.
Commercial good sense, that's right. Yeah,
that's someone like Chris is able to draw the heat out of it, I think. So Chris, your organisation is called the Commercial Disputes Management Centre, very appropriately. What's different about your centre when it comes to handling commercial disputes?
Absolutely. And I'll just say at the beginning, I was initially thinking of calling it Commercial Disputes Resolution Center, but I deliberately changed that to Commercial Disputes Management Center because it's the management really is the key word. If a dispute can be effectively managed and managed from early in its life, then resolution and early resolution inevitably, in most cases, follows. But the skill in the whole thing is in the management. But I'll just say this as to why me and why Commercial Disputes Management Center. As you've said, I've been involved in dealing with disputes, commercial disputes, for some 30 years now. So that gives me a great deal of background experience, and basically from all angles, because I've seen it through the focus of a litigation solicitor and barrister. I've seen it through the focus of a arbitrator, and then more recently as a mediator. So it really enables me to get that 360-degree look at the whole thing and truly understand the anatomy of a dispute. And this whole thing, of course, is what is central to the whole philosophy and rationale of the Commercial Disputes Management Center. CDMC was set up by me, but it operates through alliance partners. So we're basically able to take on any type of dispute that an SME might be involved in. You know, it's by coming at a dispute with the background that we have, it gives what I call peripheral vision, the ability to see what others don't or can't. It's like having on a pair of X-ray glasses that allows us to quickly diagnose a dispute when it comes to us, identify the critical and core issues quickly, and then, you know, work out the best way ahead to deal with it, what I call a blueprint, preparing a blueprint to manage the dispute. And there's a very important word in the way that we work is called triage, and triage is something that should happen at the very front end to avoid the problem out there of not being able to see the wood for the trees. You need to be able to strip down a dispute very quickly and understand what its nature is and the best way to deal with it to avoid it being prolonged, to avoid it getting aggravated and escalated. And this is what we do through a triage process. And if we need to have more than one person on the triage panel, then we will, because we'll bring to bear whatever expertise is necessary for the particular dispute that comes through the door. I'll say this also just to, again, give more background context here. As a young lawyer, I cut my legal teeth as a litigation lawyer. And from that experience over more than 15 years of going to court for people, both as a litigation solicitor and barrister, I can honestly say that there were not many happy winners and grinners in what I call the litigation game. It's a tough game, and they say that the only real winners are the lawyers. Now, you know, yes, I'm a lawyer, and yes, I've been well paid from going to court for people, but it's a sad statement, really, to say that in the litigation game, the only winners are the lawyers. I've been involved in the legal justice system as an arbitrator, as a mediator, and all that experience has brought me to this point where I am now, and over the last 5 years in setting up the Commercial Dispute Management Center, to understand the things to do early on and then in a progressive way that will ensure that disputes, most commercial disputes, and in my experience I would actually go as far as saying 98 if not 99% of commercial disputes are capable of being effectively, efficiently managed and resolved early without the need to litigate if processes within the business are set up properly, and that's what we're going to go through when we go through the 7 steps. Yeah. I want to say this. This is something really an important point to take notice of. What I am doing now, using the Commercial Dispute Management Center as the vehicle, is an approach that's strongly supported and advocated by the federal government, both sides of politics, and by an organization called NADRAC, which is the National Alternative Dispute Resolution Advisory Council, who advises federal government on the best ways to make use of ADR, assisted or alternative dispute resolution, to manage and resolve disputes without using litigation in the courts and tribunals. So don't take my word on it. They have a website, and you can go and Google it and see for yourself. Just Google National Alternative Dispute Resolution Advisory Council. But here's a problem. And I know this very well because I've been a lawyer for many years. Too many lawyers pay just lip service only to what has been recognized now for 10 years as a professional duty they have to help clients manage and resolve disputes without litigation. It's part of their professional duty of care. Litigation should be, but often isn't for lawyers, the last resort, not the first option. And by doing that, they adopt a stance that's almost opposite to this policy of government that I just mentioned in NADRAC. And because of that, they tend to pay lip service to the ADR approach, but then quickly push clients into litigious mode first. And then only then, after the client, after the business owner, is entrenched and enmeshed within the litigation system, I call it the litigation funnel or production line, where the lawyers are free to play their game, which is what they feel they're mainly trained for through their legal education and everything else, to litigate, to get resolution. There's a very, very senior person out there, Sir Lawrence Street, who used to be the Chief Justice of the Supreme Court and who's now one of the doyens in the ADR industry, made a very important point. When you litigate, you don't head towards dispute resolution. That's a misnomer. You head towards a determination or a decision by a court. It's a very different thing. So CDMC, Commercial Dispute Management Center, is basically a bespoke center, if you like, to take all this knowledge and skills and methodology and technology that can be harnessed for managing resolving disputes outside of the litigation system and bring it to bear to the benefit of the SMEs. I'll just finish up there just quickly on that, Brian, and before we move on, it's just because a lot in this, and you'll find it, of course, all available in the guidebook. But there's some things here that I really want the audience to understand, because when a dispute happens, it is almost entrenched now in psychology that you trot off to your lawyer. And I am a lawyer, but the warning I guess I want to get out there is that many lawyers are just not trained enough to adopt the approach that CDMC adopts when a dispute is brought to it, because of their, what I call lawyers' DNA. It's what they're trained to do, and it follows almost a set format. And I'm going to bring this out in the open because it really, you need to see this in juxtaposition to this alternative way of working in a commercial way with commercial people and commercial disputes. So let's just quickly run through it. When you go to a lawyer, the first step, the lawyer says, I need to find the facts. I want to know the facts. But those facts tend to only come on one side of the coin, which is the client. It's their instructions. It's not the full facts. And so properly, properly called, it's not facts. It's someone's version of the facts. And the lawyer then will consider the law and apply it to that version of facts, which may not be the whole quid, both sides of the coin. The lawyer will then tell his client, his or her client, about the legal remedies that they can get if their facts end up prevailing and being found at the end of a long process to be the truth. And then they'll say, well, you tell me that's the truth. Let's kick off. And they kick off with what's called a letter of demand. And as anyone's got a letter of demand, they know it's not a pleasant thing. And that then immediately starts to escalate the dispute. Whereas the approach that CDMC takes is the exact opposite. It employs strategies and methodologies that help contain and de-escalate the dispute right from the beginning. Lawyers are trained to do things in a particular way, which unfortunately tends to escalate disputes and aggravate them. And we all know what then happens. The person who's the receiver of that letter rushes off into the arms of their lawyer, and their lawyer takes their instructions, which is the other side of the coin, but treats it as the truth and starts to build a legal case around that. And then that's what's taken into the court process. So that's what's called a legal standoff. And this is the typical stuff of that happens in a conventional way with commercial disputes if they get handled in that way. CDMC was established to offer an alternative to that, to the SME market. And the mantra of CDMC is very, and you'll see it on its homepage of its website, is to contain, de-escalate, effectively manage, and then resolve early commercial disputes as an alternative to the litigate first approach. And to do that, there's a specific methodology. And that methodology follows this pattern. Diagnose each dispute in an objective way, and that means seeing both sides of the coin, both sides of the dispute, and highlight key commercial interests. It's highlighting commercial interests at the very front end that makes a huge difference, because we take the approach that if we're dealing with commercial people, they're willing to take a commercial approach. Secondly, keep the focus on the issues and on the relationships, and don't fall into the trap of putting the focus on the people and allowing the dispute to be aggravated and escalated because of allowing the personal differences to be accentuated. Contain and de-escalate the dispute and bring the parties into the fold of effective communication. And I cannot tell you, Brian, how often doing this at the early front-end stage is one of the most effective steps to be taken to resolve disputes quickly. Managing the communication. Often at the very beginning, both sides are hot under the collar, and when they're hot under the collar and they walk into the local lawyer's office, they are perfect fodder for the litigation lawyer's mindset.
Absolutely. It becomes sparring. They become sparring.
Absolutely. And away it goes. And away it goes.
I think the egos of everybody gets involved.
Absolutely. You're right. And then match up the dispute and the parties to the dispute with the right person or persons to effectively manage it and guide it to early resolution. Now, this in itself has a lot in it, because just like in many other areas, you spend some time to, make sure you go to the right dentist, the right architect, the right engineer, etc., etc. It's the same thing here. Not everyone has the right skill set for a particular dispute. And so in Commercial Dispute Management Center, through the triage process, we make sure that we bring the right expertise to each dispute. Then manage the dispute in a way that reduces tensions, avoid the polarization of the positions in the dispute, to avoid them becoming entrenched, according politeness, basics like this, according politeness and courtesy and respect to both parties so that they both feel that their view can be valued and respected, and then move on in a cooperative way to identifying what we call core or critical issues, and then looking and exploring the best pathways to find a way on each of those main issues to find some harmony, to find some common ground that the two sides can come around and see how their commercial interests can be taken care of through one of the possible alternative solutions. People call this trying to get the win-win, but bottom line here, Brian, really is it's not win-win in the sense of each side trying to get their optimal. It's win-win in the sense of people in business realizing that they just need to get to a point of commercial understanding and arrangement and agreement with each other that they can live with, and that will see them get back to business, working on the business and their business aspirations and goals as quickly as possible, and bring the dispute to an end. So that's the basic philosophy, and I know I've taken up quite a bit of time on that, but it was extremely important to bring out really what is this difference in the way that we work to the standard way that a dispute might be handled if you walked into the local lawyer's office.
Look, that's a very impassioned and convincing case, and I've got no doubt, having been involved in many variations of arbitrations and so on and legal cases, that what you're saying is absolutely true. It's so easy to get sucked into a adversarial sort of situation, and it does almost become a competition between the legal entities involved, where they've got a score to settle with the lawyer down the road, and this is a chance to put one on him. Unfortunately, you get involved in numerous side issues, I think, and I love the triage approach, because having that way of, I suppose, putting the light out before it starts to really, really sort of set fire to things, and those alliance partners means you're able to draw on lots of different experiences, rather than so often you go to a professional in any field and they'll always say, yes, I can handle that, I'm an expert, and unfortunately their expertise is often limited in some respects, and that's a great way of overcoming it. So
there's two models. there's really two models that we're talking about, and if you wanted to give a brief name to each, you'd say that the typical litigious approach is referred to as the competition or competitive adversarial approach. The alternative that we're talking about here is referred to as the constructive thinking, creative, cooperative approach. That's the way that it's often described in the literature.
I think that encompasses it really well and makes it very clearly understandable from a businessman's point of view. So let's get. I know you're generally going to make these 7 steps available to everyone, but let's get stuck into them and so you can just give us a quick overview so we know what's coming. So get us licking our lips here when you describe the steps. What's the first one?
I will, Brian, and I'll just say I will because we're trying to accomplish this interview within a 30-minute time thing, is just to say that I'll be fairly brief in going through these steps because I'm hoping that at the end of this interview you'll be motivated to go to the website and actually download your copy of the guidebook, and where you'll get the full expose there. But step 1 is adopting the right that will lead to better internal policies and procedures to avoid and minimize disputes. Now, there's a logical sequence here, if you like, because if you don't have this right awareness and philosophy in your business, then you're going to be more inclined to head towards that or get sucked into or decide upon to litigate, to be adversarial, to be oppositional, to be competitive in the way that you deal with with any dispute, than adopting this alternative way. So there's always an education process here in whatever. If you're, as you, I think you yourself, Brian, in your workshops and things when you're teaching people about franchising, your very first step is to increase their understanding, education, and awareness about why franchising. You really can't move on to anything else until you get that right level of awareness. Would that be right?
Absolutely. Yeah. You got to understand the game you're playing.
So it's the same here. So it's essential that every business owner who faces that risk of that we've been talking about understands the anatomy of a dispute, what lies behind it, what often lies behind it, and drives it into existence, and then spurs it on, leading to dispute escalation and loss of control. And this is where you pinpoint something that's sort of bubbling there and then crystallizes as a dispute. It's when there's a sense of loss of control over some aspect of your business relationship, either business to business, franchisee to franchisor, or franchisee to customer, or whatever. And if the business owner can has inculcated, if you like, or imbibed this higher level of knowledge and awareness about how best to manage and disputes, it will lead inevitably to a revision and updating of their internal policies and procedures. And this is something that CDMC can help them with.
Okay, yeah. So in other words, what you're doing is you get a defensive strategy incorporated in your day-to-day business affairs so that you're automatically defaulting to this philosophy.
Yeah, it's a realignment of your thinking and your philosophy that makes you amenable to and open to this alternative way of managing disputes.
Okay. Now, I appreciate the time's marching on, but I'm finding this absorbing, and I'm amazed how the time has flown. So I'm happy to indulge, and I'm sure the listeners are as well, in a few extra minutes to be able to listen to these steps quickly, because you're describing it so succinctly that I think it's an ideal opportunity to share that with us if you're happy to spend a bit of extra time, Chris.
Oh, I am, absolutely. If you don't mind me spending a bit more time, I'm more than happy to do that.
Okay, well, let's put you on a spot then. And what's the second step?
Yep. The second step is a very, very important one, often overlooked, and I can't tell you how often I see this, Brian. It's having poor contracts. So the second step is upgrade your contracts as part of your essential risk management. as soon as a dispute happens and a contract is involved, and you go to any advisor, any legal advisor, the very first thing they're going to say is, show me your contracts.
Absolutely.
And the essential point that I want to make here is that you can have many contracts that are well drafted in terms of, setting out, key terms and conditions. But often what's missing is a special set of clauses that should be there all the time if you want to bulletproof your business in the way I'm talking about, which is these dispute management and dispute resolution clauses. Now, if you cast around and look at many contracts, you'll see even some contracts that do have these, they're not drafted in a way that I would suggest they be drafted. Ultimately, what those clauses need to accomplish for you is this, that it gives you peace of mind and comfort that because you've adopted this philosophy, which is, if dispute arises, let's try to resolve it without litigation, it has a stepped process incorporated into it through these clauses that will allow every dispute to be quickly identified, contained, then to go through a sequence, which is a period of time allocated for negotiation, just party to party, but confined to a period of time, so it doesn't have time to get escalated and aggravated. So if that negotiation doesn't work within that time frame, it then moves to the next level, which is either some form of conciliation, where you might go to someone that you both say, like for instance, if it was a franchise dispute, let's go to someone like Brian or someone else who's so familiar with this area that we can expose our issue to Brian, say what I think about it, you say what you think about it, and ask Brian in a way to give us some guidance.
Yeah,
now, we don't have to take that as binding, but it might just help us diffuse the dispute. These are things that can be done very early on if you have a set of clauses that permits it to happen, and a set of clauses that require this sequence to happen before any party can go any further. So it could be to go to someone who's regarded as a neutral expert. It could be going to mediation, so a mediator will then help you resolve the dispute. Again, it's on a timeline. It might have some tricky issues in it that can't be resolved at mediation, in which case it may provide them for the parties to go and choose their own commercial arbitrator to determine finally, as a binding determination, the matters that they're not able to resolve through their own discussions or through mediation. And that's called commercial arbitration. And there's a whole act that governs that in this country and in this state called the Commercial Arbitration Act. And it's specifically set up for domestic commercial disputes. So savvy business owners these days who understand that by and large and most of the time litigation is simply time-consuming and eats up your costs and distracts you from your business will insert a certain set of clauses. And CDMC, of course, can help any business owner review their contracts and put in these clauses that will ensure that you cannot be subject to what I call litigation hijack. So I put an enormous importance on that second step.
That makes steps, that makes absolute sense. I would say that I'm going to check out the few different legal documents I've got, and I suggest anyone listening does the same, whether it's a lease or any kind of agreement you have, and make sure you've got appropriate clauses. If they're not there, then endeavour to get them implemented with the agreement of the other party if they're existing.
And Brian, I might just say off the cuff here before we move on to the next point, in case I forget to say it at the end, if people listening to this are people in your network or anyone who is contemplating being in a franchise or already is there, and they hear this interview, I want them to know that they can approach me, and you'll get the details at the end, for a no-fee review of any contract they have, for me at least to give a preliminary view to them as to whether it's crying out for an upgrade. So no charge to do that as an offer I'm going to make in this interview. Yeah.
Okay. We're skating on to the next one. The third step.
how to, his third step is about management, how to effectively manage a dispute.
The second's getting your contracts upgraded so they're all in shape and really all
Absolutely.
profiled correctly. So then your third step.
Absolutely. So assuming you've got those contracts in order, we have a checklist we use that helps manage a dispute, and it's a checklist that anyone can use, and it runs this way. Firstly, I'll go through the checklist of what not to do. Don't ignore it.
Sorry, this is the third step, is it, your checklist?
No, this third step, it includes, under the heading of management, this is a checklist of what not to do when a dispute comes up.
Oh, okay.
Firstly, don't ignore it. Secondly, don't act defensively or aggressively towards the other party, because that leads to escalation. Thirdly, don't fuel the tensions, because that will escalate it. Don't engage in intimidation of any kind towards the other person, and avoid conduct and tactics that are confrontational, manipulative, or blaming. Now, I'm giving you those matters because studies that have been done quite extensively into this area have identified those matters I just mentioned as some of the typical stimulants that cause a dispute to start getting out of hand.
Yeah, they're inflammatory, aren't they? It just so easily happens, and every trigger becomes aggressive, stroke defensive, whatever it might be.
And of course it makes the other person do the same.
Yeah, before you know it, it's a competition. It's not, no longer is it an issue or a dispute. You're looking to find a winner. It's like a boxing match,
That's it.
They're not looking for a draw. Yeah.
Exactly, Brian. And so these things that I'm mentioning, it's really a psychology we're talking about here. And anyone in business, without the need to go and use anyone else's services, can simply adopt this checklist about what not to do, and they'll be giving themselves considerable, self-help in this area.
Oh, I love
checklists.
I love checklists. I love to hear this. This is
I do too.
My bread and butter. They really, they save me so many embarrassments or expenses or predicaments. It's so simple.
I'm a believer in them too. I'm a believer in them. The chief aim here, Brian, should be, as I've mentioned before, contain, de-escalate, move it into a smooth management protocol. And an important part of this is deciding correctly when to engage an ADR expert to help manage that process for you. But if you can do the things I'm mentioning, it'll be a great beginning. But the next level of responsibility, I guess, here in being a good manager of your own business is to recognize when you need to call in external help.
Yeah, quickly, I think. It's just so easy to inflame it. And it's so tempting.
It is.
So I mean, I suppose, you're speaking from years and years of professional experience, exposure to all sorts of circumstances, and that's experience which is invaluable. But you're astute and very intelligent enough to pick it up, so you've learned from that, and hence what you're sharing with us really is the wisdom of so much case experience.
It's distilled. That's right, Brian. It's absolutely. It's distilled over a long period of time. Here's a checklist on the other side, the positive side, of what business owners could do to achieve good management of a dispute. Firstly, ensure that you apply and adhere to the protocol which is set up in your contract to manage disputes. Secondly, create an atmosphere and environment that's polite, respectful of the other party's views, firmly states your own views and reasons that support them, and focuses on approaching and managing dispute in a cooperative, collaborative way. So here you are deviating from the other way, which is the adversarial, competitive, confrontational stance. Then work together to identify the core critical issues in the dispute and accept the right of each party to start off with a different view. Just allow that to them so that you can show you're trying to understand the other point of view. Try to find what your common commercial interests are as quickly as you can, and keep the focus, keep that within focus all the way through.
Common ground.
During your negotiations, do your best to uncover and understand the other party's point of view, other party's perspective, and demonstrate some empathy. But at the same time, stand firm on identifying your own chief concerns and interests. then try to pinpoint the chief causes of the dispute and explore the options to eliminate, ameliorate, or mitigate them. And if the negotiations seem like they're getting stuck or bogged down, that's your signal to jointly together decide to bring in some external help. Yeah. And that's, of course, help that we can offer through CDMC.
Have we slipped into the fourth step there?
No, the fourth step, Brian, and I'll hurry it along.
A bit brief now. Hopefully we've finished.
Yep, absolutely.
Finished with the meat and potatoes. We'll get into the
step.
Yeah.
Will do. Step 4 is know when. It does incorporate step 4 a bit. Know when to seek expert help and how to select the right expert. Now, I won't say more than announce that to you because it's all fully explained in the guidebook. But it's that particular expert or group of experts or whatever that will set up the triage method, the triage process, so that that dispute can be quickly stripped down, analyzed, understood, so that a tailor-made blueprint can be designed for it.
Yeah, okay, excellent. And step number 5.
And I should mention, Brian, just before step 5, that is an area where we make use of our alliance partners. And if you go to the website and look at the tab for alliance partners, you'll see that they cover in a very extensive range of different fields, including yours, of course, which is franchising. Right, step 5 is be a good instructor to your expert. This is a very important area, and even as a solicitor and a barrister, Brian, one of the things that you could see happen, and I just saw this more and more later on as I was, in other roles as barrister, as mediator, as arbitrator, is that often business people, once they're taken out of their safety of what they know into unfamiliar ground, unfamiliar territory, they feel totally lost. They feel totally, what's the word? Out of their, what's the word there, Brian?
I suppose.
Out of their depth and comfort zone. Yeah, and so it's really important that business owners get properly equipped, so they can feel comfortable and in control of the whole dispute management resolution process, which may include instructing various experts. And in the guidebook,
sorry, Carol.
In the guidebook, I provide a checklist to help them do that.
Yeah, it's so easy. I can think of a quick analogy there without drawing things out. But when one looks at politicians who are trying to, rule the roost and they're being interviewed, and they're asked a question where they've been pretending to be experts and they're found lacking and suddenly they're floundering. It's something you see in business as well, where people, again, it's perhaps ego. They won't, they feel they're going to be a master of all things, and they'll tend to sort of bluff their way, and then it reaches a point where suddenly you're really caught with your pants down in literal terms because you haven't really got the knowledge. And how can you brief somebody and be a good instructor if you're not honest with yourself to begin with? I think that's a very good point.
That is, and I would just add this, Brian, before we move to step 6, that one of the worst things for a business owner is to go ill-prepared into a lawyer's office, because the lawyer will hijack the business owner, and the business owner then will feel that they've totally abdicated all their power across to the lawyer. So it's very important in the way that we work with people that come to us, is that they understand how to work with us in an effective way, and they constantly feel empowered all the way through.
Oh, look, I laughed there, and I shouldn't do it. Fortunately, I had professional training as a quantity surveyor, so minute, fine detail was something we worked out how many screws we're going to use to fix the door frame. It was really down to fine detail. So
yeah.
To me, it's sort of instinct. It's something it's a lot of work to get the detail right to brief someone, and you can be inclined to cut corners, but goodness me, it's at your own peril. Okay, those are excellent points, and they're great examples you're quoting, so it's all very memorable. So running into the 6th step.
Yep, the 6th step is to be a good communicator. Communication and I drive this home, is at the heart of most disputes. If you just think about it, Brian, in any area you want, even in personal relationships, marriages, whatever else, it's communication breakdown is at the heart of most disputes. And it leads to escalation. It leads to deterioration of the relationship and escalation of the dispute. So it's in the best interest to pay keen attention to this step and become a good communicator. And again, given that my love of checklists, I provided a checklist in the guidebook on how to become a good communicator.
Oh, look, franchising, it's one of my hobby horses. I think every franchise group should have a communication manager or officer to make sure communications are kept in touch, because so often they're not. And once the lines get fractured, it's like a bad phone line. Once it starts dropping out, you never hear the full side of the conversation. So that's excellent. I'm looking forward to getting a copy of that checklist myself, because I've been remiss.
Yeah.
I haven't done that. So, and then we're here with the final step. This is the one I'm waiting to hear. What's the seventh step?
Well, this is really what is the wrap-up, if you like, and you know, step 7 in a way is you know, make sure you bring the whole thing together, and because it's a series of steps and they have to be all utilized. But the goal here is really what's important. The goal of all this is quick, low-cost management and resolution of disputes, and preservation of important business relationships. I mean, this is really the essence and the rationale of the whole thing, and why you know, CDMC exists in the first place, is because this is what distinguishes us from all the other choices out there. You know, here's just a little aside, Brian, that we have in New South Wales, and probably similar statutes in other states and territories, but here is called the Civil Liability Act and the Uniform Civil Procedure Rules. And one of the core principles stated in that legislation, which was introduced about 10 years ago now, is that disputes should be resolved quickly, cheaply, and fairly. And this is written into the court rules now, and the purpose of it is to give courts a lot of teeth in case management.
Yeah.
But the end result after 10 years of that legislation is that we still have litigation that's takes too much time and too much expense. So you know, it really has failed to achieve that goal. But this goal is a very achievable goal if you adopt this alternative way of dealing with disputes that I've been outlining, and which is written up in the guidebook and explained on our website. Quick, low-cost management and resolution of disputes and preservation of important relationships is the essence of it. And tell me if I'm wrong, but this really has to be what most business owners would say is the way it should be.
Oh, you get on with life. I mean, they're in business to be in business, and you know, your whole life gets disrupted. So, you know, I think that's brilliant. What I think you've done quite brilliantly is applied the KISS principle, you know, to disputes. It really is, because by putting it into a process, albeit there can be quite a lot involved between steps 1 and 7, but the reality is by following that process, you know, I love it. I love the triage approach. I think that's brilliant. I think that adopting that philosophy of, you know, learning a process so that you're really prepared and you understand, so that you can avoid these things before when the storm's on the horizon, you change you change tack, sort of thing. And then as well, you're talking about upgrading your current agreements and contracts and making sure that they're all suitable. I think that's such great advice, so simple to do and inexpensive to do now.
Well, I'll just say, because we're wrapping up now, that the main objective, and I would just want to give this as an overview of everything that I've said, the main objective of what I've been saying and what's in the guidebook in a bit more detail is to equip business owners with the knowledge to take full control over 4 vital things in the business. which is number one, prevention and avoidance of disputes. Obviously, that has to be first. Secondly, recognizing that no matter what you do, some disputes will nevertheless happen, is the effective management of those disputes. Yeah. Thirdly, is the goal of early, low-cost resolution of disputes. And finally, and throughout the whole process, the protection of important commercial relationships. So those are the four main things.
I think relationships and time, if you can preserve those, you can get on and do what you're in business for. So that's absolutely brilliant. Look, to wrap it all up, our listeners, predominantly from the franchise or aspiring to be in the franchise community as franchisees or franchisors, are going to say, how can they best contact you? I've actually taken the liberty of preparing, for anyone who's watching this, I've actually prepared a slide with that information on.
Oh, great, thanks.
So I'll just move on. I think my screen appears to have frozen. No, here we are. So we can essentially then, what I've done is just put on the screen contact details there for Chris, but perhaps you'd care just to illustrate it verbally for people that are listening.
Well, I would just say here are the main things to jot down. Is one, visit the website.
Yes.
It's got a wealth of resources on it, and I will say right now that within a week anyway, you'll see the website will change. It's actually going through another revision that will be even better than it is now, with a lot of extra great content included in it, both content in text, in video, and audio. But things to mention here, it has a blog, and the blog has over 55 posts designed for the commercial market. There's a wealth of information in there. Also, click on the YouTube channel and have a look at all the videos that are up there, including a very recent webinar I did for the New South Wales Business Chamber, I think in early July. And also touch base with me on my CDMC company page, Commercial Dispute Management Center company page on LinkedIn, and also the company page on Facebook. And I invite you to become friends and get on my list there. So it makes me easier if you're interested in being updated from time to time for me to do that for you. But those are the main places to connect with me.
That's brilliant. And there is a phone number on site, but I'll give it to anyone now who maybe needs to contact Chris in the term is 02, based in Sydney in Lane Cove.
Yes.
94208213. That's 94208213. Now, I'd just like to thank Chris. He's not your average lawyer. Here's a way I'd describe it in the vernacular, because this raft of information he provides free and encourages you to look at, and the fact he's accessible for our little community here at How to Franchise, simply to have a chat to briefly or to get to review any of your documents is an invitation I think is too hard to resist. So I'd like to wrap up by, just on behalf of everyone, thanking Chris most sincerely for making the time available. I've really enjoyed this session. I've learned a lot. I hope our community have as well. So just an opportunity to say cheerio. Thanks very much indeed, Chris.
It was a pleasure, Brian. Thank you very much.
We'll speak to you all again soon and look forward to hearing from you when you've got any points of interest. Goodbye.